hear the case of In Re S.W. Ask counsel to enter your appearances.
Martha Pearce, attorney guardian ad litem.
Matthew Hilton, attorney for older sister.
Welcome, Mr. Hilton, Ms. Pearce. As you can see, Judge Orme has joined us. He is sitting in the stead of Justice Pearce, who is recused on this matter. How would you like to proceed?
We're willing to split the time down the middle,
Okay,
and I don't think I'll be using my time.
fair enough.
As I said this morning, I feel like I've presented what I need to in the briefs, and so I'm here to answer questions if this court has questions. I know Mr. Hilton has some constitutional arguments. I think the UCCJEA is probably the cleanest way to analyze.
Could you speak up just a little bit,
Oh,
or perhaps put the mic a little closer? Thank you.
Okay, is that better?
That's
Okay.
better, thank you.
So, I'm really here to answer questions. You seem to have one.
Well, I just wanted to confirm my mathematics. The older of the two children, the subject of this proceeding, the case becomes moot as to her the middle of next month. Doesn't she turn 18?
Yes. Yes, she does. And this, one of our courts has found that yeah, part of the definition of being abused or neglected is you have to be 18. So mootness is coming upon us, at least with one of them.
The order with respect to returning the children was not challenged,
No,
right?
no.
I mean, that is something that the court had to do as a matter of course. And if it was to be challenged, needed to be challenged in Kansas?
I don't think that the court had to order that. I don't think it did. As I explained in my brief, I don't think that the ICJ was ever implicated. And all of that process...
Doesn't it speak in mandatory terms, though, once the court has received that determination from a demanding state? It shall? It
shall. But essentially, that whole process began with Utah saying, we need to get our own order in front of a Kansas judge to authorize that.
So I think I'm missing something. Kansas has issued the order, and it requires the return of the children under mandatory language. I mean, you may have the other arguments. I don't disagree with
right.
that. I got that. But that's not something that you've actually challenged.
I haven't challenged that, no. No, but what I have said is that at all times Utah had ongoing active jurisdiction, and jurisdictional questions precede any procedural issues under the ICJ. Even if it is in mandatory terms, jurisdiction has to precede the ICJ.
Would you agree with me that what the court did here is essentially rule under 208? I mean, it went through part of the 207 analysis, but ultimately what it did is said, based on mother's allegedly unjustified conduct, I'm going to impute that to eldest daughter,
right.
even though there's nothing in there. By negative implication, say, since eldest daughter didn't deny that she was accomplice, and just hold her to the 208 standard.
You really get the sense that that was what was driving this.
But does 208, I guess the question I have for both of you is, does 208 even apply here? Because 208 by its very term says when you have jurisdiction by reason of the unjustifiable conduct, right? Invoking the jurisdiction, excuse me.
Exactly.
Yeah.
So
because a person invoking the jurisdiction has engaged in unjustifiable conduct. But that's not what happened here. This court had jurisdiction irregardless of any unjustifiable conduct.
the
So,
jurisdiction predated any...
so my first point is, isn't the district, or isn't Judge Bartholomew just squarely wrong in even reaching 208 in the first instance?
Well, thank you very much. Yes. Yes, that's totally how I see it. If the court otherwise has jurisdiction, then the court has plenty of remedies for bad conduct, but that's not one of them.
Yeah, this jurisdiction didn't come around because of any unjustifiable conduct.
No, no. Utah has had jurisdiction, and it became the issuing state. The initial custody determination, I think, was as early as 2004, and when there was a pretrial order in the divorce.
I don't know how to get by the language if a court of this state has jurisdiction because of the unjustifiable conduct as opposed to some other reason. And you're absolutely right.
Yes,
if you
yes.
have jurisdiction otherwise, we have contempt, we have all kinds of authority.
All kinds of tools, but that's not one of them. And particularly when the issue here is adjudicating child neglect and abuse.
So if we were to reject identify just based on the ultimate decision rests on a 208 decision.
Right.
Say, that's wrong. One, it's just wrong that 208 applies in the first instance. And two, it's wrong regardless to attribute to eldest sister any alleged impropriety based on something mother did with nothing in the record and no chance for eldest sister to be heard on it.
Right.
Do we need to do anything besides that?
Well, the one thing that I would caution is that the UCCJEA doesn't allow, the UCCJEA allows for handing off jurisdiction to somebody else, some other state. It doesn't allow to just dismiss it to nobody. And so
In a situation where 2 or more states have jurisdiction.
right, right.
They didn't wait for a pending action here or anything. They just dismissed.
They just dismissed. And the whole time, there's a case going on in district court. So we know Utah is an appropriate venue. All the information is here.
So-
And UCCJA does not contemplate 2 actions going on.
Just trying to
in 2
figure out what your
different
remedy, is your remedy limited to juvenile court? Your determination of 208 is incorrect because A, 208 on its face doesn't apply, and B, even if it did, just kind of reaching out without hearing and saying, I'm attributing mother's allegedly unjustifiable conduct to sister is just wrong.
It is just wrong. He also mentioned inconvenient form, so
But he doesn't really rule on that, and doesn't go through any of the steps.
I agree.
That you would have to go through, and he kind of just jumps from, oh, yeah, but the child's here and there would be some stuff, so I'm just going to jump over to 208 now.
yes, yes.
So, and I think I'm asking the same question in part, but if we determine that the trial judge's ruling should be reversed, is that all we do, is simply vacate those rulings and remand it? What happens next in this case?
Then we get to hear the case on the merits.
Okay.
That's what we're asking for.
So that's all you need?
That's all we need, is an opportunity to hear the case on the merits.
Okay. Thank you.
So I'm going to ask what I'm pretty sure is a rhetorical question.
Okay.
Your co-party spends a lot of time on constitutional provisions. Your brief asserts 2 arguments only. One, that under the ICJ, a mistake was made. And secondly, under the UCCJEA, our applicable statute, a mistake was made. Legal error was made at a statutory and/or rule level. No need to reach constitutional issues, or I assume you'd have briefed them.
Right. I don't think this court needs to reach them. I mean, the constitutional implications of not hearing a case are clearly obvious. But I think the cleanest way to reach this case is, as the other justices have pointed out, that the UCCJEA, that was inappropriate. You file a case, you get a chance to adjudicate it on the merits. That's simply what we're
As a
asking.
matter of statutory law.
Yes, and judicial duty, all of that, yes. Any other questions? Okay.
Thank you, Ms. Pearce. Mr. Hilton.
I could open by following up on some of the questions you've already asked my associate. I'm representing the older sister. I believe she has standing in this case. Not only was she the interested party filing the petition, but she has a sibling relationship that Henry J.P. recognized had constitutional ramifications.
But you're saying statutorily she has standing in a child welfare proceeding.
Yes, but I'm also saying that she has a special constitutionally protected relationship, and the state has a interest in protecting children. I will cover that in my brief.
Sure, but once we've said she has, if we agree with you that she has standing to be a petitioner in a child welfare proceeding, that's just the beginning and end of it for that issue, right? We don't need to go beyond that.
Well, for the standing, yes, but I believe that she's asserting a right, that she has a special relationship to these children, that even if we didn't have the statute,
Right,
She
but
could-
the problem is we don't usually start with constitutional rights. We start usually with, you know, the basic level of protections. And if a state has protected something by reason of rule or statute, and that's dispositive, we don't go
Thank you.
beyond that to reach constitutional analysis.
That's a much better job of saying what I was trying to say. If we, once we have the standing issue, we don't need to go beyond that in order to reach your client's arguments.
Well, there are two issues that I believe show a difference between our perspective on how this case would be handled on remand. As I've understood constitutional violations, if an action is unconstitutional, the action is void. If it's unconstitutional, that would mean then that the girls would be, status quo would be, they'd be returned here and assume the position they assumed before they were sent to Kansas. I specifically pointed out in my brief that the Kansas,
But we would be voiding the court's ruling. So whether it's on constitutional or statutory grounds, if we were to send it back, it would say, this determination is nullified, vacated, of no legal force or effect. I'm not, and maybe I'm just being dense, but I'm not seeing what you get in addition by us reaching constitutional grounds that you actually wouldn't get just on the statutory grounds, as your co-counsel has suggested.
well, my co-counsel says you'll have a rehearing in light of what the guardian.
Well, not a rehearing, a hearing.
hearing.
An actual hearing, subject to the actual procedures.
Right. Now, in this little chart that I've done here, I've tried to summarize some of why I think we have reached constitutional issues. For example, you may recall in the Brigham Young University versus Tremico cases that dealt with a gentleman named Duncan as well. They didn't have authority to proceed against him because he had never been made a party to the action. And Judge Naring wrote in for the court that opinion that just because you violated a constitution, a rule of procedure doesn't mean that it rises to a due process violation.
So, Counsel, if I could, sorry to interrupt, but go back to Justice Simonis' question. So, Ms. Pearce wants a hearing, and you want to, based on the statutory violations, you assert constitutional violations, and what do you want? What would be your remedy?
My remedy would be to facilitate the ability of having the proceedings go forward. I want the girls back in Utah the way they were before.
But you'd have to ask the trial court for that. We can't, we're not in a position to enter that order. That would be a petition in the first instance to go to the juvenile court
But the
on remand.
But the girls were here when the unlawful action was taken, removing them.
Yeah, but then you would be arguing that based upon that, and whether it's void as a result of constitutional grounds or void as a matter of statutory interpretation, that's what ought to happen. But that's still an argument that I think you'll have to make in the first instance before the juvenile court.
But if the girls were here and they were willing and ready and able to testify from here, having been, I hope we don't say that detention's a neutral environment, but they were here and were present and prepared.
But what we would be saying would be that the trial court erred in making that determination, in failing to permit the children to be heard, and in failing to permit the appearance of the older sister. I mean, but we only hear things on appeal, and that there is, the appeal here has been taken from orders of the trial court, and the discussion we're having now, I think, presupposes that we would, if those turn out to be the prevailing arguments, we would vacate all of those orders below, all of those orders that you claim are erroneous. So that would restore the status quo. Now, getting the children back to Utah would be something new, because that wasn't in place when you first appeared before the trial court. You'd have to ask the trial court
The girls were
for
in
an order
Utah.
requiring that.
The girls were in Utah.
That's what I'm saying. What's new is that now they're not. And so you're going to have to ask the trial court to get them back.
And there was another basis that I had for raising the constitutional issue. And that is in the ICJ, section 131, parentheses 1, parentheses B, lowercase b, it says that the ICJ can be suspended in the event that there's a conflict with an interstate compact or a constitutional provision. Now that's a statutory designation that specifies the right to raise a constitutional conflict.
That's right,
Demonstrate-
but the point is, when do you need that? You don't need that if the statutes are working for you.
I just pause to think for a minute.
Sure.
Your Honor. If I could respond on two matters that I don't know that they would be exactly the same when you go back. There was concern expressed that there was a very unusual positive relationship built with the guardian ad litem that was earlier in this case that had asked to have the girls.
Which I'm hard of hearing.
Sorry.
Would you repeat that just a little bit, please?
The record is replete that the girls had communicated fully with the guardian ad litem, and she had advocated strongly for them to testify before the court. The order of the court dismissing her order to show cause, the one he entered on April 14th, specifically says that the guardian ad litem will remain during the appellate process. An example why I'm interested in the status quo being specified is, does that mean that there'll be the same guardian ad litem will no longer be available because the remand, the appellate procedure would be over with? And
No, the children would still be entitled to the representation of a guardian ad litem
no,
in
no.
ongoing proceedings before the trial court.
No, I understand that part. That's statutorily mandated.
Right.
And it's always done. I'm talking about the guardian ad litem who had established the relationship with the girls, and they were sisters, and they were able to make disclosures that hadn't been made otherwise.
Right.
Whether it's time or content or whatever, I don't know what they all were. That guardian ad litem's involvement and appointment in the case expires when the appellate process is over with by the court order.
Well, this is one where I'd have to defer at least to Ms. Pearce, who's very familiar with how the guardian ad litem's office works and those appointments occur. Can you enlighten us at all on that question?
Well, what we're asking is that the case be heard on the merits. If it is heard on the merits, then obviously the guardian's appointment is
It's a matter of
there.
statute. The guardian has
Yeah.
got to be there in
Yeah,
a child
it's not-
welfare proceeding to represent the.
No, I understand that. He seems to, I think Mr. Hilton's talking about getting the same person.
And that's a matter of office policy. The
That's
court-
what I
The
thought.
court may appoint the office, but it's up to the director to decide who.
Ah, okay, so that's a problem you need to take up with Ms. Pierce. But it's not something we could, I think, order sua sponte, that a particular individual. Of course, that individual's testimony would always be available whether or not he or she.
Nobody's challenged that below.
Right.
Well, I was very concerned about that would occur. The alternate matter that I'm concerned about, and this is just from a practitioner's perspective as well as in the nuances of this particular case. It is unclear to me, this court's position regarding the 60-day timetable to have the adjudication heard. If those rules had been followed, the adjudication would have been heard before the ICJ ruling was ever made. And we have the one case dealing with Judge May, recently was decided where the council had stipulated to the extension of time beyond the 60 days, and that was upheld. But we have the Henry Anderson opinion, both of these are in my brief, where the court said on first blush and a first appearance, it seems that that's a legitimate question to ask whether the legislature can order 60-day timetable on the judiciary. Now, that is a significant question for the sister who's bringing the petition on remand. Both, will she have a guardian ad litem that has the prior background, the prior knowledge, and the confidence of the girls? If so, the 60 days may well be doable. We don't know. We had efforts to bring in Randy Hyde, Dr. Randy Hyde, who had evaluated the girls to a significant degree before they ran away. He was not allowed to come in. We need to have him or others get prepared. It may take us longer than 60 days to proceed forward on the merits. And finally, the order to show cause, as filed by the guardian ad litem, requested the girls be brought back because of misconduct of the father and failing to follow the safety and protection plan in favor of the children. Now, since those were not heard, and my client believes unlawfully, I think that that does constitute a denial under Article 1, Section 11. You notice that I recognize this as a new ground. I could find no precedent.
Well, the problem is it's not before us on appeal. We don't have an order of the trial court on that question which you're asking us to do anything about. And everything's got to start with the trial court. We can't review actions that have not yet been taken or decisions that have not yet been made.
But we had the decision made that did not proceed forward in any possible
Right, that's on
framework
appeal.
that didn't occur in 60 days.
That's on appeal, and that's what we propose to decide. But what happens after that is going to be done in the trial court.
Yes, I understand that. All I'm trying to say is that the denial of hearing the order to show cause, the case of Henry B.W.D, where you had the adoption proceeding and they tried to go back afterwards and get attorney's fees and contempt for not following the rules, not following the agreements that were made before the final adoption was granted. I noted in my 24J submission that this case is different than that, arguing that the contempt authority stood and should have been heard because we have a statute that allows juvenile courts to impose contempt, and the contempt hearing goes to the merits of the action that should be reinstated. And the only other issue is the separation of powers arguments that were raised. I think in particular the legislative one, where they delegated under the ICJ, they could adopt national rules that had to have the same effect as statute. That seemed to me to be a delegation because that rule still stands, saying that if there's abuse or neglect allegations, that was why the judge ruled the way he did. He said, I don't have to make best interest because of this new rule that they have. He says that's up to Kansas to decide. Yet the order to show cause shows that the safety plan that was put into place for the girls, as shared between and evolved between different agencies, was not followed to the detriment and damage of the girls. And for this, the other alternative reason why we have unusual matters for remand is I cited it at the end of my standing and constitutional specialized standing argument that this court had ruled that placing the petition places at issue the parent's right to have custody of the child. And because of that, that in my mind raises the whole question of, can a parent who's subject of an abuse and neglect petition maintain custody of the child or children, recognizing the possible mootness on the oldest daughter's situation, can that parent remain with a presumptive custody award during the pendency of that litigation? I think to do so interferes with my client's, the older sister's, ability to proceed forward and be heard. And that is an access to court problem in my mind, and it clearly bespeaks of an unnecessary delay that we've had a full year trying to be heard on this issue. But that is why I feel there's constitutional relevance in the rulings that could be appropriately made in this case.
Okay, well, thank you very much, Mr. Hilton, Ms. Pearce, and once again, we do apologize for inconveniencing you today, and we appreciate your arguments. We'll take this matter under advisement, and we are now adjourned.